West Legal Ed Center and Celesq welcome you to today's program titled Claims Made Settlements Are More Common Than You Think. Program materials can be found under the Supplements tab. Use the Participation tab at the bottom of your screen to send a question to the speakers. It's my pleasure to introduce our speakers for today's program, Kevin Skierzowski and Ross Weiner. Thank you for joining us today. I'll now turn the program over to Attorney Skierzowski.
Len, thank you very much for that introduction, and I would like to thank the audience for joining us today for a discussion on claims made settlements are more common than you think. Thank you for your time. So this is Kevin Skierzowski. I'm a director at Certum Group, where I work with companies and their outside counsel to design optimal litigation risk transfer solutions to help them achieve their legal, business, and financial objectives. Prior to joining the Certum Group, I worked with law firms and companies to design customized legal business solutions while working at companies such as Bloomberg, Thomson Reuters, and LexisNexis. And today, I am very pleased to be joined by my colleague and co-host, Ross Weiner, a legal director at Certum Group. Ross works at Certum Group, where he helps evaluate new business, assess legal and financial risk, and create optimal settlement designs and risk transfer solutions. Prior to joining us here, Ross was a partner at the law firm Kirkland & Ellis in New York City, where he defended businesses in class actions and other types of commercial litigation.
Hey, great to be with you, everybody. Thanks for the introduction, Kevin.
Certainly. So today we're going to be taking a deep dive into class action litigation, specifically structuring certain types of settlements. We're going to be looking at claims made settlements and common fund settlements. So I think it's first important to give a little bit of a background on who we are and what we do here at Certum Group. So we are a full service litigation consulting firm. We have a very large platform of litigation risk transfer solutions that include things such as litigation insurance products, premium finance, asset monetization, non-recourse litigation funding, and capital protection or portfolio wrappers. Most of us over here are former attorneys. Ross and I are both former attorneys. We have folks who were plaintiffs' lawyers, defense lawyers at AmLaw 100 firms, and several folks who also worked as clerks for federal judges. We also have financial professionals and investment bankers and insurance underwriters and actuaries. And what we do is we work together to design bespoke litigation risk transfer solutions for companies and their clients. Now, one of our largest verticals is actually in the class action space. And what we do is we work with businesses and their outside counsel who are involved in active class action settlements to help them design optimal claims made settlement structures. And then we also work with them to provide an option to also insure those settlements to cap any of the downside risk. In terms of our experience working on class action matters, we've been in business for about 10 years. For anyone in the audience who have seen Ross and I present CLEs before, you may be more familiar with our other company, Risk Settlements, which was just rebranded to Certum Group earlier in the year. But over the course of the past 10 years, we've worked on about 500 consumer class action settlements, and we have helped U.S. businesses expunge several billions of potential exposure. So today, what we're going to do is we're going to start by doing a little bit of an overview of the market, the litigation market and the class action market in general, to review some key trends and statistics, so that first, I want to make sure everybody has a complete understanding of how impactful class action is on U.S. businesses and how many class action lawsuits businesses are facing and what areas are they primarily concerned about. After that, we're going to look at the two potential class-wide settlement structures that companies can engage in, and that would be the differences between claims made and common fund settlements. After that, we're going to take a deep dive into a few case studies where we will actually review several recent court-approved claims-made settlement structures. The conversation after that will continue into several different risks and rewards for structuring a class-wide settlement with a claims-made structure. We'll talk about some available insurance products on the market that can cap the downside risk of those particular types of structures. And then we'll wrap up the program with some more case studies. We'll review cases that settled with a claims-made structure that were also underwritten by available insurance products. So starting off by taking a look at the market in general. So when we're looking at the entire litigation market, we can see that there's a $23 billion market for legal services in litigation. And out of that, 3.6 billion is actually spent on class action defense, which is about 15% of the total market, which is a relatively large number. I do want to point out that many of the data points that I'm going to go through here today when we're doing the market overview are from the 2023 Carlton Fields Class Action Survey, and also some additional information that was pulled from Statista.com. For those of you who are unfamiliar, Carlton Fields does an annual survey. They just completed their 12th one in a row, where they look at the entire landscape of class action filings, litigation, settlements, trends, statistics, and forecasts for the future. So I think you can find that program on that survey on their website, or if you want to reach out to me directly, I'd be happy to send you a copy. So in looking at what companies are spending, companies actually increased their percentage of the legal budget allocated to class action defense last year by 14.4%, which is a very large number. And it's very important to note that spending on class action cases has actually increased for 8 straight years, and it's expected to be one of the fastest growing areas of all legal practices, and it's estimated to grow to somewhere between $3.8 and $3.9 billion over the course of this year. Something else that's also very important to note is that 60% of all U.S. companies are defending at least one class action lawsuit. In looking at the top class action matters by nature of suit, we see that there's 2 primary areas that really dominate the filings: labor and employment and consumer fraud. We can see that these account for about 55% of all class action matters. And I think the reason that we see a large number of labor and employment filings is because regulatory agencies and employees through their counsel are just in general being more aggressive, especially more aggressive in post-COVID litigation. And then I think that the 22% that we're seeing of all consumer filings in large part is due to claims resulting from the use of social media, product labeling from any consumer packaged goods, particularly food and beverage manufacturers, and debt collectors who continue to be sued regularly for alleged violations of the Fair Debt Collection Act. And moving on to some other key trends and statistics in this area. So we can see that the amount of spending on class action defense is supposed to increase in 2023. So we see that it's estimated to go from about 3.6 to 3.8 or 9 billion, very, very large number. I had mentioned that the total number of major companies that are currently dealing with the class action lawsuit is almost 60%, so almost 3/5 of all US businesses. We can see that the number that go to trial is very small. It's always been insignificant. This number has not changed in years. We say 2%. I think sometimes, this could be argued that it could be even a lower number, sub 2% at times. The results of the survey where I gleaned this information was collected from about 400 businesses. So it's a very, very large number. Perhaps those were the ones that were sued most often, and therefore they go to trial most often. But that's a very, very small number, which I think which makes our discussion here today on claims-made settlements even more valuable. In looking at the average number of class cases that a company is managing at any particular time, this is really a daunting figure: 9.6 cases, just class action cases. What makes it even scarier is that 43% of these cases are considered high risk. So you have a massive amount, almost double-digit numbers of cases, which is expected to also increase this year, and almost half are high risk or significant high dollar value pieces of litigation. And then I think some of the two most important statistics that are germane to our discussion here today is that 72.5 is the number of the percentage of class action settlements that required an affirmative claim for payment. Meaning out of all of the class-wide settlements last year, 72, almost 3/4 required an affirmative claim or a claims-made settlement structure. But we see that the use of charitable contributions as a part of class-wide settlements decreased from 43% in 2021 all the way down to 23.5% last year. Now, for those of you who are familiar or aren't familiar, normally the use of the charitable contribution, or what is commonly referred to as a side-prey distribution, is leveraged in the common fund settlement structure, where there is a payment to each member of the class, an equal payment or a payment of a benefit to each class member, and what isn't used from being paid all the class members then reverts to a charity, and we're seeing a significant reduction in that. And I think it's interesting how you see this non-correlated statistic between charitable contributions decreasing and a large number of class-wide class action settlements that require an affirmative claim for payment, which is very relevant to our discussion here today. Which brings me to my first poll question. So I'm really curious for all of the members of the audience to know, how many class action matters are you currently defending? 1 to 2, 3 to 5, 6 to 10, or more than 10? Now, I know there is no way to actually do the poll, but there is an option for participant feedback that you will see on your screen. So if anybody would like to reply to the poll question using the participant feedback button, you can go ahead and do that now. I'm just checking on my ask a question feature here, but I'm not getting many responses, which is not unusual. Let's,
What do you think? 10 more seconds? Oh, I got it. We got a response. So the link is working, so that's good news.
okay.
Thanks to the responder. All right, should we keep going, Kevin?
Let's go ahead and move on to the next section.
Okay. So the next section talks about sorry, let me just move the slide. Thank you. The common fund settlement structure. But before we talk about this, I actually wanted to stay on the topic that Kevin raised for a second about 2% of class actions go to trial. That's from the Carlton Field survey. You know, it's a really interesting statistic. Historically, it's always been very low. It continues to be low. And there's always that question of, why is it so low? And I think, you know, one of the answers is, you know, in the last 2 years, you know, there have been a handful of cases in just off the top of my head, BIPA. There was a trial on BIPA, the BNSF case that resulted in a $228 million judgment. In TCPA land, there was a $267 million award in the Rash Curtis case. And then in consumer fraud land, the case involving Joint Juice resulted in I think an initial judgment of 136 million, although it's subsequently been reduced, I think, fairly significantly. But all of this is a long way of saying that these headline cases are the kinds of things that get the attention of GCs and AGCs to these big numbers. And, you know, a large part of settling class actions is, de-risking, and a lot of part of what we do is de-risking, but the numbers can be so exorbitantly high in class actions that it has always been an area of law that is ripe for settlement because the risk and the unknown, uncertainty is just too large to take to trial. So turning to the two structures that we're going to talk about here. One is a common fund structure, the other is a claims made structure. I would be remiss if I didn't mention a third that we're not going to get into because it's pretty self-explanatory, but the third type of general settlement is an individual settlement, and that's one where even though the plaintiff has brought a purported class action, that person settles on an individual basis long before class certification. Usually the plaintiff walks away with a little bit of money, the plaintiffs walk away with a little bit of fees, and the parties maybe make some kind of injunctive relief or change to the product, and then they go their separate ways. In the Carlton Field Survey, interestingly to note that those settlements are way up this year. 46.2% of settlements were individual settlements. There is stuff to be read into that. Sometimes individual settlements can be driven by plaintiffs' firms who are looking for kind of quicker strike deals, right, where they get the injunctive relief, but they also get what's called a small payday, and the plaintiff gets a small, measure of reward, and then kind of move along. And so those settlements have been up this year. But of course, that leaves the other 54%, which are class settlements. And so starting with the common fund settlement structure, that is where the defendant agrees to the total cost of the settlement will pay, i.e. the common fund, and that's the pool of money from which all settlement expenses are deducted. Now, what are those settlement expenses? Well, they generally include valid claims that are made by the class members in the U.S., plaintiffs' attorneys' fees and expenses. Of course, those are subject to court approval, but generally, the more traditional approach is that the parties will agree not to oppose an award of fees up to a certain amount. The plaintiffs then have to file an application for fees, and the court has to sign off on it, but usually those fees come from the total amount of the settlement. They usually include class representative incentive awards. Those are traditionally between $5,000 and $10,000. Although I would note, for practicing folks out there, I believe it's the 11th Circuit in the past year has effectively banned the use of class representative incentive awards, relying on some very old Supreme Court decisions for doing so. That is an issue where the other circuits are all in disagreement with the 11th Circuit. And so while the Supreme Court has not yet taken that issue up, my guess is in the next 5 years that might come to a head where it becomes a question of whether class representatives can benefit from an amount different and separate from what the class is getting. And it's usually a nominal, like I said, $5,000 to $10,000 for their time and effort in bringing litigation. And then the last expense that's generally included in the settlement fund is the settlement administration cost. That's for the party that comes in, helps provide the notice, helps process all the claims. And of course, those costs are variable, but we always recommend folks use highly reputable administrators because that's a very important part of the settlement. The amount that each claimant receives in a common fund settlement is generally based on how many claimants file valid claims. So if it's let's say it's a $10 million settlement and there's $3 million in attorney's fees, and let's call it $1 million in other fees, right? That leaves $6 million for the valid claims, and that amount is generally adjusted pro rata so that it exhausts the fund. Because as Kevin mentioned earlier, one of the interesting developments in the law is that cypre has gone. It was very popular for a time, and then courts started pushing back, and objectors started pushing back on cypre awards because either the third party that received it wasn't closely related to litigation, or for more kind of due process arguments, right? That it doesn't make sense if most of the award is going to some third party that doesn't move litigation. Is that really a fair result? Anyway, so the amount each claimant receives is based on how many claimants file valid claims, and the overall amount owed by the defendant is set on day one, meaning the day that the settlement is signed, and that's where the maximum amount that they will have to pay is laid out. and the parties get comfortable with it. Interestingly, the 2023 Carlton Field Survey found that consumer fraud class actions currently pose the biggest class action risk to companies. That's definitely an interesting statistic. And for the common fund kind of side of things, on the positive side, the fact that the total amount that the defendant will owe is known on day one is clearly a positive. And generally speaking, plaintiffs' attorneys tend to prefer this structure because knowing how much the defendants are going to spend helps them in their support their application for attorney's fees. And so generally there's, between the two, there's a slight preference for common fund structures. On the negative side, by fixing the amount of relief, it means that every dollar has to be distributed if there's not a cypre recipient. And so this ultimately can result in class members reaping windfalls, right? So if there's, in my example before, there's $6 million available for claims, and there's only, just to take a crazy example, right? There's only 6 claimants, right? That would mean each claimant would receive $1 million from the settlement fund, even though the product they bought might have been worth, $1, $10, or $100, right? And so that's the kind of windfall that generally the law disfavors, but that can come into play in a common. Going to the next slide. Kevin, do you still have control of it, or?
Yeah, no problem. Sure.
Okay. So in contrast, a claims made structure means that the defendant's total bill is based in part on how many claimants file a valid claim. Remember, with the common fund, it doesn't matter how many file a valid claim, whereas in a claims made structure, it does. This type of settlement is prevalent in situations where the defendant lacks data on how many members may be in the particular class. For example, small dollar consumer product class actions where there aren't receipts, right? Like let's say it's a labeling of a pack of gum or a shampoo bottle or whatever what you may have, can lend itself to a claims made settlement structure. Class members are able to recover their fair share. Each claimant receives a benefit amount the parties agreed was fair and the court ultimately approved. Like I said, in contrast to the common fund, there are no windfall payments if only a small number of claimants submit claims. And there are no de minimis payments if a large number of claimants submit claims. I would say one caution on that bullet point, this ultimately comes down to a question of whether the settlement is a capped settlement or an uncapped settlement. Just for a quick understanding of that concept, an uncapped settlement means the defendant is responsible for all valid claims, regardless of whether there are 10 or 10 million. So if the benefit amount was, let's say, $5, right, and there were 10 million claims, then the defendant would be responsible for $50 million in payments, whereas if there were only 10, they'd be responsible for $50. And so in that situation, in the event that there are 10 million claims, right, there wouldn't be a pro rata reduction or some kind of de minimis payment. Rather, everybody would be entitled to that amount. In a cap settlement, that's where, while it might be a claims made structure, it's claims made, but up to a certain point, meaning when there's X dollars worth of claims that are submitted, the defendant is no longer responsible for paying more than that. And so to achieve that result, the ultimate payment to each claimant will be reduced pro rata so that the number doesn't go above the ultimate capped amount. And so, for cases where proof of purchase isn't traditionally available, claims made structures are critical. And these are cases where, oftentimes you'll hear defense counsel talking about what they consider baseless cases, right? Which are, foot faults on labeling or, something that's, 99% true and 1% false, and then somebody files a complaint. But interestingly, in the Carlton Fields 2023 survey, they noted that 6 in 10 in-house attorneys agree that baseless claims bring a substantial risk in the class action front. And I found that statistic pretty interesting, mainly because, while one person might consider it baseless, if it has enough legs to get by a motion to dismiss, that can open the door to exhaustive and extensive discovery, extensive attorney's fees, defense costs, etc. And so, one person's baseless can be another person's, mighty big headache with respect to. If we go to the next slide, head to head. this is kind of a summary of what I just said, but, in a common fund settlement, full settlement amounts paid by the company, there's no reversion. That's a term you hear often where, in a cap settlement on a claims made structure, right, the cap is the most that the company would pay, but if it's under that, it used to be the money would go back to the defendant. Oftentimes those structures, the money never leaves, it's only that their defendant is responsible for how much, how many valid claims there are. In a common fund, the full settlement is paid by the company, so there is no reversion. The full amount paid by the company on an after-tax basis. Obviously, this can require extensive notice plan. Defense counsel fees continue, and while some folks prefer common fund settlements to claims-made settlements, there's no guarantee that a court grants final approval to a common fund settlement, and there have been many that have had significant trouble getting through the court system in recent years. Whereas a claims-made settlement, at least from our perspective, we think is a far more cost-efficient structure for defending businesses, particularly if it's capped. Benefits can be tiered so that those with better claims, like proof of purchase, can receive a greater award. And this is a more equitable settlement structure, which avoids massive windfalls for claimants or small benefits. Now, if we go to the next slide, it's a quick case study, Cleveland v. Whirlpool. For those of you at home who have Pacer or Lexus accounts, that's the case citation is 20 CV01906. It's a District of Minnesota case. This was a 2022 settlement. The background is a woman named Elizabeth Cleveland sued the Whirlpool Corporation for selling allegedly leaky dishwashers, and she sued on behalf of 6.7 million class members. That number was derived because I think Whirlpool estimated that there were 6.7 million dishwashers affected by this problem. Ultimately, after a long battle, a lot of briefing, motions, etc., the court granted final approval to an uncapped claims-made settlement that created different award tiers based on the age of each dishwasher. And for each year after the unit's manufacturing date, the award decreased slightly. So, the older it was, right, just using kind of basic depreciation principles, the less amount of money the claimant got. For newer models, they got more money. The settlement structure was for dishwashers 1 or 2 years after manufacture. The plaintiffs were eligible to receive $225, which was the average cost of repair for the leak. Owners of dishwashers older than 7 years could receive up to $67.50. And cash rebates were offered for those who opted to buy new appliances instead of repairing. A couple things that are interesting about this case. One, as I mentioned earlier, many folks think that it's hard to get claims-made settlements approved in federal court. This is not entirely accurate. Courts, as we'll point out today, routinely approve them, and oftentimes, one of the biggest holdbacks with a claim-made settlement is not so much the claims-made structure as it is plaintiff's counsel perhaps asking for too much in fees, which can lead to objectors, which can lead to problems down the road. In this case, for example, there were only 2 objectors out of the 6.7 million potential class members out there, and neither of whom had a meritorious objection, and the court approved the settlement. And then going to the next slide to finish with this case study, the plaintiff's damages expert estimated that the value of the settlement would be somewhere between 15.7 million and 21.3 million, depending on the ultimate take rate. And I believe that the reason for the uncertainty and the guesstimate here was that the claims period would be open for a pretty lengthy period of time, given that I think the leak was considered somewhat of a latent defect that wasn't necessarily readily apparent on day one, and so there was time left for folks to still discover the leak if they didn't opt to buy a new product. And so here, the court granted final approval of the settlement and approved plaintiff's counsel's request for approximately 1.5 million in attorney's fees. That 1.5 represents somewhere between 6.5% and 8.5% of the estimated value of the settlement fund. From my perspective, that's a very reasonable request, which is probably why the court granted it. I think by doing that, as opposed to asking for 30%, right, of somewhere between 4.5 and 7 million, right, that could have drawn an objector. And I think one of the interesting things about this Whirlpool case is it shows a great amount of creativity in the settlement process. Basing the value of the benefit on how old the dishwasher was, offering cash industry, but if you want to place it entirely, etc. This was a very creative way to use a claims-made settlement to resolve a case and in a very efficient way for the defendant. So with that, I'm going to turn it back over to Kevin, and maybe it might be a good time for you to read that code as it's halfway through.
Yep, sounds good. We are exactly halfway through. So for those New York practitioners who are looking for CLE credit, this message is for you. In order to comply with New York regulations, attorneys looking for CLE credit in New York will need to be able to provide a code. This code is not intended for the West Legal Ed Center audience, either live or in demand. I will read this code twice and only twice and cannot repeat it or email it to you, so please make note of it. The New York State code number is S as in Sam, W as in Wendy, 33108-60623. Again, the New York State code number is S as in Sam, W as in Wendy, 33108-60623. And with that, let's take a look at a few more case studies where claims-made settlements were approved in federal court. So moving forward, we'll take a look at Coppolis versus Harbor Freight Tools. This was out of the Central District of California. So this was a class action lawsuit that basically claimed that Harbor Freight Tools sold defective chainsaws. Allegedly, there was an issue with the power switch and the machine not turning off even when the user tried to turn the machine off. There were a large number of class members, about 800,000 members nationwide during the class period. In terms of the individual the settlement structure that was designed for the individual class members who submitted a claim form without proof of purchase were entitled to receive a $10 cash payment or a $25 gift card, which was limited to one claim per household or IP address. And class members who submitted claim forms with proof of purchase or proof of destruction were able to receive up to $50 in cash or a gift card for each class product purchase, especially if they attested that they did not participate in the prior recall or prior disposal of the chainsaws. So at the end, what we saw was that the parties had an estimated settlement that was valued anywhere between $8 million and $40 million, depending on how many class members filed claims, who filed them without proof of purchase, with proof of purchase, or who took the vouchers or chose to have replacement chainsaws. So at the final approval hearing, the court approved the claims-made settlements, and the plaintiff's counsel's request for approximately $650,000 in attorney's fees and expenses was approved as well. Moving on to one more case study of a federal court approving a claims-made settlement. This is Broomfield versus Craft Brew Alliance. This is a fun case, and this is from the Northern District of California. So in this particular lawsuit, there were several beer drinkers who sued Craft Brew Alliance for misrepresenting where their beer was brewed. There was a beer brand named Kona, and so the named plaintiffs alleged that they paid a premium for this particular product since they thought that the beverage was brewed in Hawaii, when allegedly it was actually just brewed in the continental United States. This class, again, a very large class, almost 8 million, 7.8 million Kona beer drinkers, beer purchasers. And in terms of the settlement structure that was designed on behalf of the individual class, this was a claims-made settlement structure, and purchasers without proof of purchase were eligible to receive up to a $10 benefit per household, while purchasers with proof were eligible for up to $20, these are pretty standard settlement structure figures for individual class member benefits in food and beverage false advertising cases. Now, in this case, as Ross had mentioned, one thing you have to be careful for is when you have these settlement amounts that are uncapped. So in this situation, it was claims made, but that settlement amount was uncapped. However, the settlement agreement stipulated that Craft Brew Alliance did have the right to terminate the agreement if more than 1 million claims were filed. But now what that effectively means, if you have 1 million claims, everybody who comes forward has proof, you're actually looking at about a $20 million damages cap. So in the end, what happened is that all the claims were submitted. The class did not, in fact, reach the $1 million claim threshold. And at the approval hearing, the court approved the settlement and awarded the plaintiffs' counsel about $2.26 million, which was a little bit less than their request, which was just a skosh over $2.5 million. So there's
Kevin, do you have any sense of why folks would build in kind of that 1 million claim threshold or something along the lines of that? Is there something they're protecting against that type of provision?
Well, I mean, that's a blow provision to protect them in the event that could trigger potential fraud that was coming in from the lawsuit. That's one reason why you may do it. That's something I'm going to touch on a little bit later in the program as well. So when you have these false advertising types of cases that affect consumer packaged goods or food and beverage companies, the issue is that many times they get picked up by promotion websites or feeder websites like topclassaction.com. And so there's no way to contact the class directly. There was no direct manufacturer to consumer record. You can't email them or call them. They sell it to stores and big box stores and grocery stores, and then we as consumers go in and we buy the products. So normally we have to be notified of the class through publication as opposed to direct notice. The only issue is that when you have a publication notice campaign and you have a without proof of purchase cash benefit, basically anybody can go in and they can apply to get that $5 or $10 or $20 benefit. And so sometimes those blow provisions are put in as a fraud control, which then would give the defending business and their administrator the option to go back in and see where all of these claims are coming from. Are they coming in from one IP address? Are they coming in from one feeder website, basically indicating that people who are coming in to claim the cash benefit really aren't even class members. That's one main reason.
No, that makes a lot of sense, and something we've definitely seen from time to time is, settlements involving very well-known brands. It doesn't usually happen to brands that aren't well-known, but very well-known brands, like the one that's maybe the most famous example is Red Bull, right, where a settlement goes absolutely viral is the expression that folks use in this industry, and that, starts getting passed around. It hits a younger demographic, and all of a sudden, everybody, not just 1 million, but maybe 10 million people are filing claims, right? Way more above and beyond the folks that actually purchased the product. And because there's no way to verify that these people actually purchased it, it becomes kind of an administrative nightmare for the settlement administrator.
That's exactly right. That's a great segue to our very next slide, which is the risks and rewards of claims made settlements. So, it's a variable structure, and so there are rewards and there are risks to the potential defendant. So, on the one hand, if the number of valid claims made is very low, then ultimately, your pay it could ultimately cost the defendant less than it would otherwise have paid if they were in a common fund settlement structure. But on the other hand, and perhaps more importantly, these can go viral, like we're discussing right now. So really, there's a way, though, to control the risks, and that's going to be in the next section when we talk about some available insurance solutions, that are on the marketplace. But I had mentioned the difference between like direct notice and publication notice campaigns. So, and this impacts a lot of the businesses who are in the consumer manufacturing space, which ties into the statistics we discussed earlier about these same companies keep getting sued over and over. So, if you're a company that, let's say, you do a lot of outbound calling to try to get new customers, stay in touch with new customers, you could often be, have alleged exposure for TCPA violations, or, if there could be some type of like fraudulent fee case, in those types of cases, who you reached out to. Like if it's a TCPA case, who you called, who you texted, who received the fax. If there is some type of fraudulent fee, like an overcharging case, you probably have a record or a receipt of what the charge should have been, but it actually was. You can contact those people directly. There are fraud controls that you can build in to the notice administration and claim program to make sure that those people who were potential class members are only the ones who are coming forward to stake a claim, and there isn't any fraud. However, if you have any type of false advertising, which again is impacting consumer brands and is like the second highest percentage of class action lawsuits that are being filed these days, it's very difficult to protect against it. And I had mentioned, there's a lot of feeder and promotion websites that promote the settlement and the cash that you can receive without the proof of purchase. There's companies like talkclassactions.com, classaction.org, openclassactions.com. Even Yahoo Finance has a section on how you can claim money from open class action settlements. Not to mention, sometimes there are settlements that even have their own Facebook page. Or I'm told by my teenage children that there's even now social media influencers on outlets such as TikTok that promote settlements of certain products. And then actually, what's even scarier, and most recently, there's this phenomena which is relatively new, and that's overseas claims coming in from the same IP address or the same bot that programmatically hits a settlement website to file a claim. We actually have one case in administration right now, and in that one case, we have 35,000 hits that came from that same IP address, which we tracked. Looks like it came from somewhere in China. So while there are many benefits to structuring claims-made settlement, we always caution that it's also very important to make sure that you have the proper fraud controls in the claims process to verify class members. And it's also very important to consider mitigating and capping that risk through insurance policies that are available in the marketplace.
Hey, Kevin, before you go to the next slide, we got a good question I wanted to just address really quickly.
Great.
And the question was, is it possible to do only a gift card as payments for a valid claim, or does the gift card rebate always have to be an alternative to a cash option to get approved? So this is a good question.
Yeah.
I would say, pretty briefly, that when you enter the world of gift cards as part or a key part of a settlement to a class action, you have to pay very close attention to the Class Action Fairness Act, otherwise known as CAFA. That lays out the particulars with respect to how to value a gift card settlement. And for folks that don't know, obviously the difference between cash and gift cards, right, is that cash is money that's going out the door to individuals, and they're going to it's going to go through Zelle or Venmo or check or however you may have it, but that money is going to leave the defendant's pocket and go to the individual consumers. With gift cards, it's a little different, right? You can distribute gift cards to 1 million class members, but it doesn't cost the defendant anything unless and until those gift cards are actually redeemed. So CAFA has a number of provisions about how you value settlements involving gift cards, including that you can only value the amount that actually is redeemed by the class members with respect to valuing the settlement and evaluating attorney's fees. And there's a whole series of tests as to what constitutes a gift card settlement versus a cash settlement. Don't need to get into the particulars of that, but there are gift card settlements are available, but there are a number of hoops you need to jump through to make sure that they are A, approvable, and that B, you're basing on how much money is actually redeemed, so the plaintiff's counsel is entitled to a property.
Yeah, I think that's right. I think could be a whole separate discussion on gift card versus what's designated as a voucher or what's a coupon, and then does the consumer actually have to take money out of their own pocket to then have a full replacement of a potential product? And to your point, Ross, it's a very good one. You have to, when you're looking at those gift card payments, sometimes you have to deduct the COGS or the cost of goods sold. You can't factor in the potential profit that's coming back to the company in the gift card that you're using. You have to remove that amount. It just should be like the cost for you to potentially produce that product that's then going to help the consumer purchase a replacement. But what we always advise clients is that cash is king. And there is some law out there also that says that the attorneys will be paid based upon how the class is compensated as well. And so you also run the risk that it will be difficult to justify your fees that you're getting at from the plaintiff's side if all you're giving to the class is a gift card and not cash.
Correct.
But did have another poll. We didn't have a lot of responses, but I was just curious, for anybody who has entered into claims-made settlements in the past year, did you have any? How many did you do, or did you only just do common fund?
Don't be shy, folks.
We can, if you just want to move on, Ross, we can keep tabs on people answering and get a dive into the insurance products.
Sure. Yeah, that makes sense. Okay. Well, moving on. So, Kevin alluded to, some of the risks that are attached to claims-made settlements. And quite frankly, the question, when I was practicing and discussing with clients the option of doing claims-made settlements, the question from the company's CFO, the two questions that were most frequent, right, were one, how many claims will be filed, and two, how much is it going to cost? Obviously, those two are related. With class action settlement insurance, you're able to provide that CFO with an answer to the question. So, as a brief description, class action settlement insurance, or what we call CASI, is the only product on the insurance market that allows companies to mitigate, cap, and transfer the financial risk of settlement in active class litigation. CASI eliminates the unintended consequences of settlement, helps businesses exit litigation for a known fixed cost, and so it's underwritten on the paper of a leading national carrier with second to none ratings from AM Best, Standard & Poor's, and it is maybe revolutionary, might be overstating it, but it is certainly a novel and incredible tool for businesses in most after litigation has been filed. So to clear up one point of confusion, CASI is not something you need to buy as a company like D&O insurance ahead of time, and then if you're sued, you tap into your claims response team. This is something that you would buy as you're going through litigation to protect against, to protect your specific claims-made settlement that you enter into. It is the only product on the market that kind of lets you do it. Funny story I had is, I was helping a former colleague with a class action settlement and kind of going through how this worked and what the pricing might look like. And I got a call, a week later saying, really appreciate it all the time, but is there anybody else I can get a second quote from on this product? And I had to kind of sheepishly respond, like, there's only one, right? And this is the product, and so I wish I could help you further, but that's it. And so, CASI is a really interesting product. And if you go to the next slide, get in some of the particulars.
Sure.
Coverage is available for a full spectrum of consumer class cases. So fraud, false advertising, product liability, data breach, invasion of privacy, statutory claims like TCPA, and other types of litigation. It can help with cases, big and small. So there's no difference really between a mislabeled, shampoo bottle with a $2 benefit or a TCPA settlement with approximately $200 benefit. CASI can be used to protect defendants in either of those cases. In terms of the stage of active litigation, Certum Group can be retained at any stage without any upfront cost or obligation as a consulting-only expert in order to case-specific data, better understand your case, the potential exposure, financial risk, and how to potentially resolve it in a way that achieves the defendant's business objectives. While companies can leverage the Certum Group's expertise at any stage, from the time the lawsuit's filed to right before a settlement is signed, to be clear, the policy is only issued once a settlement has been reached. And so, this is important. The process of obtaining CASI is generally speaking an iterative one, and by that, the defendant provides us information on the case, how much they're looking to spend, what the benefit they're thinking about, capped or uncapped, and then based on that preliminary information, we can give you a preliminary quote of what that might cost. But that settlement is only good so far as we can agree with you on it, but it doesn't mean anything unless and until the plaintiffs agree. So as you negotiate your settlement with the plaintiffs, right, and they have certain terms that they need met that increase the risk profile, right, you come back to us, explain what those are, and we can revise pricing almost in real time to kind of get you up to date information. And at the end of the process, right, if in fact the client wants to go forward, the amount for the CASI policy, the premium in insurance speak, will ultimately be, that will reflect the risks of your particular settlement that at that point will be locked in stone. So all the settlement terms will be negotiated and agreed upon, and the insurer knows exactly kind of what settlement they are insuring. Go to the next slide. Sorry, thanks, Kevin. So how does it work? CASI's purchased to transfer the settlement risk in existing class litigation. A policy covers only the valid claims that are made by class members under the settlement agreement. So just to be clear, generally speaking, a CASI policy does not cover the other expenses that the defendant will have to endure, including the notice of administration, the defense counsel, the class representative awards. Those will still be paid by the defendant. The policy only covers the valid claims that are made by class members during the claim period. In terms of key benefits, right, you get the benefit of a claim-made settlement, but without the uncertainty of how many claims there will be and how much it will cost you. By that I mean, yes, there's still uncertainty as to the final number of claimants that there are, but because you're buying the policy, your only expense with respect to valid claims is that one-time premium, and then the insurer owns the risks of all the claims that come in. The insurer owns the risk of the settlement potentially going viral, etc. This provides certainty for companies to help with budgets, forecasts, and expenditures. This is the one item that used to drive CFOs when I was involved in negotiating these settlements crazy, right? Because a claim-made settlement could have a wide range of value depending on how many claimants. And so for companies that are smaller in size, having to take a reserve for the bigger amount or the maximum exposure, could be problematic for various financial reasons for the company. And so, in effect, it minimizes P&L and balance sheet impact, removes the concerns over the uncertain payout, mitigates internal friction and opportunity costs, and negates the unintended consequences of the settlement. A couple other notes, just briefly. We always work with clients on helping them select an excellent settlement administrator to oversee the settlement administration. As Kevin mentioned earlier, that's a key part of these settlements, especially where there's without proof claims, because there is a risk of fraud, and so we want, you really want an administrator that's on top of their game, who knows kind of the traps to run to keep out those fraudulent claims. And to be clear, CASI can be used with both capped and uncapped settlements, and CASI provides an answer to your CFO's question, how much will this cost, and is this the most efficient settlement? Once you turn to a CASI policy, the answer to both, I can tell you exactly how much it will cost, and yes, this is the most efficient way to settle the case. I think with slide 22, Kevin, I think we're back to you.
So with that, let's look at a couple of examples. So there was a global transportation company that was sued for overcharging customers $160 million. This was actually an airline who allegedly overcharged executive club members. So there was a very large class, over 160,000 members. Even for an airline, clearly, 160 million in exposure can cause significant balance sheet impairment. It can lead to some unintended financial consequences that Ross had mentioned, such as things like weakened financial statements. There could be reduced or missed earnings forecasts, impediments to cash flows, and other business operational issues. In this particular case, there was like a wide range of fees that were going to be paid to the class members. The average fee was about $160. They were concerned with those unintended consequences of settlement and that $160 million of exposure and the impact that it would have on their balance sheet and business volatility that could cause. And we designed a settlement structure that had a cap of $27 million in exchange for a premium of 6, which represented just 4% of the overall liability that we expunged for the business. Second, there was a national fast food company who was sued for allegedly making 1.1 million violations of the Telephone Consumer Protection Act. This was actually a fast food chain. They sent 1.1 million customers a text advertising their food product, and they didn't have, I'm sure we all probably know, the opt-out language at the bottom of that text. And so the lawsuit really came at a bad time for this particular nationwide chain. This was actually a pre-COVID case. The business had been rapidly expanding their brick and mortar stores across the country towards the Pacific, and they had perhaps expanded a little bit too quickly. Their sales were down for a couple of consecutive quarters. They had some turnover at the upper management level. And so a cost-effective settlement structure was at the utmost importance for the company, for the overall stability of the business. At the end of the day, their lawyers were able to negotiate a claims-made settlement, but they were very worried about the downside risk, and they were looking for a way to mitigate, cap, and transfer that risk. So we were contacted. We worked with the lawyers in conjunction to create basically a $10 benefit per class member, which equated to an $11 million capped settlement, which was insured for a $1.4 million premium, which represented just less than 1% of their statutory liability, because of course that statutory liability that comes with TCPA cases is very daunting, even when they're small classes, much less when there's a class that has 1.1 million people. Taking a look at a few others, we worked with a global defense company that was sued for a potential, like a fatal defect in one of their handguns, actually, and there was over 1 million units sold. Very well-known product, very well-known brand. Of course, a lot of people that use them or in armed forces or police, and so there was a lot of concern about the volatility of the settlement. Their lawyers were able to negotiate a claims-made settlement, but again, they were very concerned as to how many people would participate in that settlement, which was about $20 million. So we were contacted, and we actually insured it for a premium of 3.8 to really keep the company solvent and mitigate some of the viral claims that could come from a very high risk settlement. But I did want to just give one more example that isn't included here today, that goes back to sort of like the fraud that goes along with false advertising cases, since that's a significant portion of filings that we're seeing across the country in all federal and state courts today. So about a year or two ago, we were working with a consumer packaged goods companies on a false advertising matter. For those of you who aren't familiar, there's types of case that is very popular with the plaintiffs bar right now called serving size cases, where really any packaged product with a measurable serving size could really be an issue. It could be anything from like baby formula to coffee to laundry detergent. Anyways, we were contacted by this large Fortune 500 food and beverage company, and they were looking to structure and ensure a settlement for one of their cases. There was a lot of concern because they had sold 1.2 billion products of this particular household product, which is really a ubiquitous thing that a lot of us use. And they were very concerned about protecting themselves from the downside risk, even though the settlement structure that we created was pretty benign. It was a settlement structure where each individual class member would get $5 without proof and $25 with proof. The settlement was capped at $10 million, and the premium was about 1.6. However, this settlement was picked up by many of the feeder websites that I previously mentioned. And at one point during the administration, the total claims had exceeded the premium by millions of dollars. So again, just want to implore the listening audience that when you're negotiating your claims-made settlement structures, which are very cost efficient, cost effective for defending businesses, be very careful to ensure that you have also negotiated the proper fraud controls in the notice administration and claims process, and consider taking advantage of some of the insurance products that are available in the marketplace that can mitigate, cap, and transfer that risk. And with that, we have less than 1 minute remaining. And so let me refresh and see if we have any other. We have one more We had a question earlier, does the risk transfer include admin costs or claims payouts? Only. Good question. So there are 3 individual costs for a claims made settlement that is coupled with an insurance policy. One is the cost of the premium for a bespoke insurance policy, which would cover 100% of the valid claims that come under the settlement agreement. The second cost would be the cost for the administration for notice and admin. And the third would be the cost that you were to pay the plaintiff's lawyers. The insurance policy would only cover the unknown of the claims that are coming in under the policy. The other 2 are negotiated separately because they're more known. You would understand the size of the class. You can get a quote from an administrator. And then by that point, you probably also have a general idea of the fees that plaintiff's counsel is seeking, whether it's based upon a percentage of their recovery or on their lodestar. And I do not see any other questions. Ross, any other final parting comments?
I just wanted to thank everybody for joining us today. We hope that this has been informative, maybe even a little enjoyable. And if you have any questions with respect to structuring a claims made or common fund settlement for that matter, please feel free to reach out to either Kevin or me. We are the Certum group, and we are happy to take your call whenever you are available, and we're happy to work with you. And again, thanks for joining us Tuesday afternoon.
Yep. Thanks again for everybody for joining us for claims made settlements are more common than you think. My contact information is on the screen if we can answer any follow-up questions. And with that, we have exhausted our hour. Thank you for attending.
I think you have to read that code one more time.
All right. And one more time, for those New York practitioners, the New York State code number is S as in Sam, W as in Wendy, 33108 60623. Again, the New York State code number is S as in Sam, W as in Wendy, 33108-6023.